Hare Krishna. Welcome to Tax YouTube channel. This is CRO Pingale, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to the video series What Law Says, and today we are going to discuss two important Bombay High Court judgments under income tax law. So let's dive into it. Let me allow to share my screen. Yes. So we will discuss two important Bombay High Court decisions which have significant implication for tax practice. With increasing automation in tax administration and growing complexity in compliance requirements, issues relating to procedural fairness and corrective remedies have become what increasingly relevant. So the first case here examines whether adjustments made by CPC, that is Central Processing Center, under Section 143 subsection 1 must comply with statutory requirements of prior intimation. And the second case for today's discussion explores what the scope of revisionary powers under Section 264 and how the law protects the taxpayer from injustice arising due to the inadvertent errors. So together, these judgments provide important guidance on balancing the administrative efficiency with taxpayer rights. So let's dive into it. Let me start with the first slide. Let's understand the purpose of selecting these cases. So automated processing by CPC, errors or omissions in return filing, protections of legitimate claims, natural justice in tax administration. So both cases demonstrate how courts ensure that technical lapses do not override substantive justice. So moving further with our first case, Bax India Ventures Private Limited versus CPC, Bombay High Court. Relevant assessment here is not applicable here. Date of order 2nd February 2026, very latest. So relevant sections here, section 143 subsection 1, section 115 BAA and section 139 subsection 1 of the Income Tax Act 1961. Let's understand facts of the case. The assessee Bax India Ventures Private Limited filed its return of income claiming concessional tax rate under section 115 BAA. So to claim this benefit, the company was required to file Form 10IC, okay, within the due date prescribed under section 139 subsection 1. However, the return was filed belatedly under section 139 subsection 8A and Form 10IC was also filed along with the belated return. So while processing the return under section 143 subsection 1, the Central Processing Center, that is CPC, disallowed the concessional tax rate and computed tax at a normal rate. So CPC made this adjustment without issuing prior intimation to the assessee regarding the proposed adjustment. So the assessee challenged the validity of the intimation itself before the Bombay High Court. So what was the issue under consideration? So the CPC, that is central issue before the Bombay High Court, was whether the CPC can make adjustments while processing a return under section 143 subsection 1 clause A without issuing prior intimation to the assessee and without giving an opportunity to respond. So sub-issues included here whether denial of concessional tax rate amounts to an adjustment under section 143 subsection 1 and whether the requirement of prior intimation is mandatory or procedural. Very important. So let's see what are the relevant legal provisions here involved in case 1. So section 143 subsection 1, that is processing of return. Under this section, the return of income is processed by making what? Certain adjustment such as arithmetical errors, incorrect claims apparent from return, disallowance of deductions where return is filed beyond due date, disallowance based on audit report. However, the first proviso to section 143 subsection 1 provides that no adjustment shall be made unless intimation is given to the assessee, that is opportunity of being heard. The assessee must be given an opportunity to respond within 30 days. That is very important and mandatory. So let's see what were the contentions of the assessee. The assessee contended that the adjustment made by CPC violated the first proviso to section 143 subsection 1. No prior intimation regarding the proposed adjustment was issued. Assessee was not given an opportunity to explain or respond, and therefore the adjustment was illegal and the intimation order should be quashed, is what contended by the assessee. So what contentions, what are the contentions of the revenue? So revenue argued that the assessee was not eligible for the concessional rate under section 115 BAA. Form 10 IC had not been filed within the due date under section 139 subsection 1. Therefore, the CPC had correctly denied the benefit. The revenue also contended that the issuing intimation would be fertile since the assessee was clearly ineligible for the benefit, is what contended by the revenue. Now let's see what High Court observed. High Court examined the statutory language of section 143 subsection 1 and observed requirement of issuing prior intimation is mandatory. It should be. Revenue cannot decide unilaterally that issuing notice will be fertile. So assessee must be given an opportunity to respond before making any adjustment. So the court emphasized that failure to issue failure to issue prior intimation amounts to what violation of statutory provisions and the principles of natural justice. So High Court held that the adjustment made by CPC without prior intimation was invalid. Impugned intimation order was quashed and set aside. Revenue was allowed to issue fresh notice and proceed in accordance with the law. Thus, the petition filed by the assessee was allowed. Now, moving further, let's understand the principles laid down by the first case. So this case established several important principles like mandatory compliance with section 143 subsection 1 proviso. Opportunity of being is essential before adjustment. It is a mandatory. Administrative convenience cannot override what? Statutory safeguards. Automated processing must still follow due process. So natural justice applies even in automated tax assessments. Very, it is clearly a principle laid down by this case. So now moving case law 2 for today's discussion. Ramesh Madhukar Deole versus Principal CIT, Bombay High Court. Relevant assessment year is 2018-19 and date of order is 18th November 2024. Relevant sections, section 54F, section 142 subsection 1 and section 264 of the Income Tax Act 1961. So let's understand facts of the case. The assessee filed return of income for AY 1819. However, return was initially filed in the wrong form due to incorrect advice by the any profession. So any professional. So the assessee later filed a corrected return claiming exemption under section 54F. So during scrutiny proceedings, assessing officer issued notice under section 142 subsection 1. Assessee's chartered accountant failed to respond properly to the notice. So consequently, the assessing officer passed an ex parte assessment order making additions. Assessee filed a revision petition under section 264 before the principal CIT seeking relief. Very interesting. Let's understand what were the issues under consideration. The core issue before High Court was whether the principal commissioner was justified in rejecting the revision application under section 264 as not maintainable. And the broader question was whether section 264 can be invoked to correct the mistakes made either by the assessee or by the tax authorities. So let's see what are the relevant legal provisions. 264, that is revision of orders. 264 empowers the commissioner to revise any order passed by subordinate authorities. And important features of this can be invoked by the assessee. Power is discretionary but very wide enough. Intent to correct the injustice and that can be exercised even where the no appeal has been filed. So this provision is meant to provide what relief in cases where the assessee has no other effective remedy. So let's see what were the contentions of the assessee. The assessee argued that assessment order was passed ex parte. The chartered accountant failed to comply with the notices. And assessee subsequently produced all the relevant evidence before the commissioner. So assessee contended that the section 264 is intended to correct the such mistakes. Revision should be decided on merits. So let's see what High Court observed. Bombay High Court made several important observations like Section 264 confers very wide powers on the commissioner. Provision is intended to remedy injustice. Very important. The provision of the section intended for remedy injustice arising from errors in assessment. Even mistakes committed by the assessee can be corrected through revision. Very important to note. Even mistakes committed by the assessee can be corrected through revision. So the commissioner must examine the matter on merits rather than reject it on a technical grounds. So the court emphasized that Section 264 is a beneficial provision designed to ensure the fairness in tax administration. So therefore, what High Court held, the Bombay High Court held that the rejection of the revision application of the assessee was erroneous. Commissioner failed to exercise the jurisdiction properly. Accordingly, the impugn order was quashed and set aside, and the matter was remanded to the commissioner to decide on the revision on merits. So moving further, let's see what principles laid down by this case. So this judgment established important principles like Section 264 has very wide remedial powers. Revision can be invoked even to correct mistakes of the assessee. Technical grounds should not defeat the substantive justice. Commissioner must exercise revisionary jurisdiction to the prevent injustice, and beneficial provisions such as Section 54F should be interpreted liberally. So, while overall conclusions, we can come to the conclusion that the Bombay High Court judgments reaffirm fundamental principles of the tax jurisprudence. That is, procedural safeguards cannot be ignored in automated assessments. Also, revisionary powers exist to correct what genuine mistakes and prevent injustice. Courts have emphasized that the tax law must be administered fairly, reasonably, and in accordance with the principles of natural justice, and therefore these rulings serve as important guidance for tax administrators, chartered accountants, legal practitioners, and taxpayers too. So that's it for today. Thank you so much for patient hearing. If you have any questions, observations, suggestions, then do let me know via WhatsApp, or you can also email to me, and also you can comment below the video. Thank you. Thank you so much. If you have not yet subscribed Tax Guru YouTube channel, then do subscribe for latest updates and video series like this. So stay tuned to the Tax Guru YouTube channel. Thank you so much once again. Bye bye. Take care. See you soon. Hare Krishna.